Anand?
Sir, yes, sir. Sir, shall we start?
Anand?
Sir?
Anand?
Yes, sir. Sir, கேக்குதுங்களா? Sir, yes, sir.
கேக்குதா?
எனக்கு நல்லா கேக்குது, sir. Sir?
Shall we start 4:15?
Yes, sir. Sir?
Speakers வந்தாச்சா?
Yes, sir, yes, sir. Sir, கேக்குதுங்களா?
Okay. கேக்குதா?
எனக்கு நல்லா கேக்குது, sir.
Dinesh, wait for 2 minutes. Wait for 2 minutes.
Yes, sir.
Friends, this is Sridhar, the President of Revenue Bar Association. I'm extremely happy to call you people for this first meeting, study circle meeting. Every third Saturday of every month, the third Saturday, we used to meet and discuss the important issues under direct tax and indirect taxing and also other laws. Today we have two fascinating and young and energetic speakers. One is Dinesh. He's a youngster in true sense, and important issues under direct tax and indirect taxing and also other laws. Include the CAs also in our fold. I have invited a few of the CAs. We will go on increasing our invites in the next meetings. And I'm extremely thankful to all CAs and the other invitees in joining this Zoom meeting. And with this opening remarks, I hand over to Mr. Anand, our Vice President, to conduct the proceedings. Thank you very much. And I'm extremely thankful to all CAs and the other
Sir, shall we start the meeting, sir?
Yeah, you can start. You introduce Mr. Dinesh and you can comment the proceedings quickly.
Yes, yes. Good evening and welcome all to the first study circle meeting of the Revenue Bar Association.
You introduce Mr. Dinesh and you can comment the proceedings quickly. Yes.
Good evening and welcome all to the first study circle meeting of the Revenue Bar Association for the period 2023 to 2025. In today's study circle meeting, we will be navigating between tax topic and non-tax topic. We have with us today a young and dynamic speaker, Dinesh Inba Vadivu. Dinesh did his bachelor's in computer application from Ramakrishna Mission, Vivekananda College.
Application idea.
And thereafter graduated in law and enrolled in the year 2017.
Passport.
Soon after his enrollment,
Others, please mute.
Application idea.
and enrolled in the year 2017. Soon after his enrollment,
Others, please mute.
he joined the chambers of Mrs. V. Ramchandran. He practiced both in direct and indirect taxes and enrolled in the year 2017. Soon after his enrollment, he joined the chambers of Mrs. V. Ramchandran. He practiced both in direct and indirect taxes and appears before ITAT, CESTAT, NCLT, and High Court. He has penned various articles in direct taxes and has also authored a book on 14A titled How Much is Too Much, published by Commercial Law Book House. With the advent of idea of conflict management, which is alternate dispute resolution, a new, less adversarial method of settling legal disputes has become available. Many contracts today carry an arbitration clause which say that if any kind of dispute occurs, it will be resolved through arbitration rather than directly going for litigation. There are at least 4 distinct forms of alternate dispute resolution: arbitration, mediation, collaborative law, and negotiation. Time is absolute and priceless. Every single stride taken in a technology advancement is somewhere related to skimp time. If advancements cannot economize time, then they are no advancement. Our second speaker for the day is G. Ashokapati, who will be addressing us on ODR in ADR. ODR is a branch of dispute resolution which uses technology to solve disputes among disputants. Ashokapati is the founder, partner of a law firm, Pass Associate, and is also a founder member of CNICA, the first arbitration center set up in the state of Tamil Nadu in the year 2002 and established under the aegis of Trust for Alternate Dispute Resolution. Its principal area of practice is civil and property law, tax laws, insolvency law, and of course arbitration. He has been appointed as ad hoc arbitrator in more than 20,000 cases and has also been appointed by Madras High Court as arbitrator in multiple cases. He is accredited arbitrator and is empaneled as an arbitrator in various institutes and is also a member in World Intellectual Property Organization. He has addressed various forums on arbitration and has been regularly publishing articles on arbitration. He is accredited arbitrator. Now may I call upon Dinesh Indavalivu to the digital dais. Dinesh, the dais is open to you.
Yes, sir. Thank you so much, sir. Shall I start, sir?
To the digital dais. Dinesh, the dais is open to you.
Yes, sir. Thank you so much, sir. Shall I start, sir?
Yeah, please go ahead, Dinesh.
Yes, sir. So, I should, first of all, I should thank Mr. S. Sridhar, the President of the Revenue Bar Association, and the Vice President, Mr. D. Anand, for giving me this opportunity to talk about the recent judgments of Supreme Court. And I think I'll do justice to what I do today. I think the very firing issue that has been before the Supreme Court for quite some time is about the reopening of assessment after 1/4/21 by the unamended Act under 148. So due to COVID, there was an legislature enacting TOLA 2020, wherein the notification were released by CBDT extending the time limit for issuance of notice under section 148 and completion of assessments and approval sanctions and all that. I've just shared a screen where I have where you can see the Taxation and Other Laws Relaxation Amendment of Certain Provisions Act 2020. I'm not going directly into the decision of the Supreme Court in the first place. I'm going to give an overview of what happened prior to Supreme Court judgment and what is the stand that is taken before Supreme Court and how the case stands today and what will be the impact and what would happen in the near future. So that is my idea of projecting this presentation. So this TOLA 2020 was brought into on 29 September 2020. Prior to this, it was an ordinance, as you all know. The main intention of TOLA was only to extend the time limits. For issuing of notices for which time limit was expiring. That is the main intention of bringing in TOLA. I'm only talking with respect to 148 notices. Chapter 2 of TOLA deals with the extension of time limits. That is relaxation of certain provisions of the specified act. Section 3, if everyone can see section 3, it only says where any time limit has been specified in or prescribed or notified under the specified act, which falls during the period from 20th day of March 2020 to 31st day of December 2020, or such other date after 31st day of 2020 as the central government by notification specify in this behalf for completion of or compliance of such action. And the highlighted portion where completion or compliance of such action has not been made within such time, then the time limit for completion or compliance of such action shall, notwithstanding anything contained in the specified act, and extended to the 31st day of March 21 or such other date. Here, what the legislature by TOLA has attempted to say, or rather it has said, is that it has only extended the time limit. On a plain reading of it, on a bare perusal of TOLA 2020, one would say there is no deeming fiction. Had there been the words that the notices issued between 1/4/21 and 36/21 shall be deemed to be construed as notices issued on 31/3/21, there could be a debate as to what is the interpretation with respect to deeming provision. But the TOLA 2020 is very clear. It only extends the time limit. It only talks about the extending the time limit. There is no deeming fiction at all. So therefore, by TOLA, the legislature itself clarifies the position that the original date is only the extended date of issuance of notice. Say, for example, if 148 is issued on 1/4/21, I'll just come there. This can be related to the Supreme Court decision in Ashish Agarwal. I'll just come in a bit later now. Subsequent to TOLA, the central government, the CBDT, has issued 2 notifications wherein the time limit was extended to 34/2021 and subsequently to 36/2021. So therefore, what the TOLA tries to do is, if notices issued on or after 33/21 shall be extended till 36/2021, meaning notices issued on or after 1/4/21 and 36/21 is the only target. Here, it would be pertinent to take note of the explanations in both these notifications. I have highlighted the portion of the explanation. For removal of doubts, it is hereby clarified that the purpose of issuance of notice under 148, as per the time limit specified in 149, or sanction so and so, under this subclause, the provisions of 148, 149, 151, as the case may be, as they stood as on the 31st day of March 21 before the commencement of Finance Act shall apply. This clearly clarifies the position that the old provision shall apply. That is, the old unamended 148, 149, 151 alone shall apply. And by this, the TOLA stalls the provisions of the new Act, Finance Act 2021. Now, these explanation to AA2 and explanation AB were challenged by various high courts, including Manmohan Kohli, Vellore Institute of Technology, and all that. And various high courts have declared this explanation appended to this notification as ultra virus, and further went on to quash the notices issued for the assessment years 13-14 and 14-15. Now, as you all know, that these batch of appeals were taken up before the Supreme Court in the case of Ashish Agarwal. Ashish Agarwal was a lead case, wherein the Supreme Court, the Honorable Supreme Court, gave a concession to the Income Tax Department and directed all the notices issued under 148 under the Unamended Act between 1421 and 3621 to be construed as notices, show cause notices issued under 148 capital AB, and provide information within 30 days from the date of the decision of Ashish Agarwal. The decision of Ashish Agarwal was rendered on 4th of May 2022, and 30 days from that ends on 4/6/2022. Now, subsequent to the decision of Ashish Agarwal, the CBDT tried to attempted to clarify the position, or they tried to thrust upon their own interpretation by issuing an instruction number 1 of 2022, which you can see in the screen that I've shared now. So this is the instruction based on which the CBDT has attempted to interpret in its own way, interpreting the judgment of the Supreme Court. Now, before this, the Supreme Court, while directing the notices issued under 148 to be treated as show cause notices, it also very clearly stated that all the defenses available under new 149 shall be applicable to the SSC, shall be available to the SSC, and the SSC and the department as well shall take cognizance of the new provisions of 149. Now, the CBDT tried to attempted to interpret this decision. This is very crucial. The Honorable Supreme Court has upheld, this is the words of the CBDT. Honorable Supreme Court has upheld the views of high courts that the benefit of new law shall be made available even in respect of proceedings relating to past assessment years. Decisions of Supreme Court read with the time extension provided by TOLA will allow extended reassessment notices to travel back in time to their original date when such notices were to be issued, and the new 149 of the Act is to be applied at that point of time. Now, nowhere in the Supreme Court decision of the Ashish Agarwal, the Supreme Court dealt with traveling of time or giving a scope to the what is original date. Now, CBDT has attempted to clarify, they attempted to create a new fiction by saying that there is some concept called original date. What do the significance, what does it actually mean? Is it the original date of 148, or is it some other date that the CBDT is trying to thrust upon the SSC to treat it as original date? That has been clarified by the CBDT itself at point 6.2, which I've highlighted. For assessment years 13-14, 14-15, and 15-16. Now, just to explain this, I have also for assessment year 13-14 and 14-15, the 6 years period as per the old provision ends on 31/3/2020 and 31/3/2021. The CBDT tries to now say that the original date is only 31/3/2020 and 31/3/2021. Why is the CBDT trying to say that this is the original date? Now, this is only because to counter the proviso to 149(1)(b), which is inserted with effect from 1/4/21, wherein original date has been taken to 31/3/20, on which date the proviso will be applied. The proviso to 149 very clearly states that no 148 notice shall be issued at any time in a case for the relevant assessment year beginning on or after 1/4/21 on account of being beyond the time limit specified under the provisions of 1B of this clause. That is, to put it in simple words, if you're not able to reopen the notice, you reopen the case after 6 years with as per the time limit provided in the unamended provisions, you cannot try to invoke or reopen the assessment with respect after 1/4/21. That is the intention and clarity that the Finance Act 21 has said by enacting the proviso to 141. Now CBDT, from nowhere it came and it said that 31/3/20 and 21 should be the original date. This is only because CBDT, by its own notification, in the it stated that it extended the due date from 30/3/2021 to 36/2021. By doing this, CBDT is trying to evade from this 149 proviso. So trying to apply this 149 proviso and reopen the assessment. Likewise, for assessment year 17/18, for example, CBDT itself states that the original date is 2021. We don't know on what basis CBDT is trying to say that the original date is 2021. Because as we all know that for assessment year 17/18, as per the new provision, any case can be reopened up to 10 years from the date of issuance of reopening notices. So for 2018, from the end of the assessment year, for 2017/18, 10 years period expires on 2028. So CBDT, the department has time till 2028 to reopen the assessment. Now, what prompted the CBDT to come to a conclusion that original date should be construed as only 31/3/21? This is not known, but this could be culled out from the CBDT's own circular, which only states that the intention of the CBDT is only to bring this into the 149(1) of the new provision, meaning that if for assessment year 2017/18, that is the year ending 31/3/2017, if the original date is to be construed as 31/3/21, they can evade this and they can very well say, even if the time limit, even if the monetary limit of 50 lakhs is less, even the monetary limit is less than 50 lakhs, they are entitled to reopen the assessment for 17/18. That is not the intention of the Finance Act at all. Now, this instruction, according to all of us, most of us, it is erroneous. And all these bunch of writ petitions challenging this instruction have been filed before various high courts for the only reason that the instruction is erroneous interpretation of the Supreme Court decision. By this TOLA, this one point that needs to be noted down is by the Taxation Amendment Act, this TOLA 2020, new provisions were stalled. That is very clear. And now CBDT is attempting to apply the same from 1/7/2021 for the sole reason that the notification extended the notices to be issued between 1/4/21 and 36/21. So now CBDT, by its notification, by its instruction dated 11/5/2022, is trying to unsettle its own earlier interpretation by attempting to apply new 149 on 31/3/20 and 21. That is even before 149 was brought into the Finance Act by the legislature. It is like the legislature legislates the law and the CBDT applies its own interpretation and comes to a conclusion that this is the original date and this is the extended time limit. Nowhere in the TOLA, nor in the CBDT, nor in the Supreme Court decision, there is a whisper about what is extended time limit and what is the original date. Supreme Court has very clearly laid down that 149 defense is always available to the SSC, but the CBDT, having pointed this out, is trying to escape it. Now,
Dinesh, can I come in for one doubt over here? Ashik here. Dinesh, on this point of 149 versus 149, that proviso, specifically Supreme Court, what they said to my mind is what gets replaced is only the 148 AB notice, which is the first notice under the.
Correct.
Dinesh, you can take questions at the end.
Yes, sir. Yes, sir. I'll take it, sir. Thank you.
You can go in your own flow and you can answer the questions at the end.
Yes, sir. Sure, sir. Yes, sir. Thank you, sir. So now, this concept of original date and extended time limit has not been answered till date, except for one High Court of Bombay in the case of Voltas. Now I'll share that screen of Voltas. The assessment year involved in this case is assessment year 15/16. If you can all see the screen that has been shared now, I'll read the relevant portion. This is the finding of the Bombay High Court with respect to how this extended time limit or the original time limit applies with in pari-materia, in co-joint reading of the 114 of the new provision. Para 23. Even for a moment, we agree with the view expressed by respondents Still, it applies to only cases where the limitation was expiring on 31st March 2020. In the case at hand, the assessment year is 15-16, and therefore the 6-year limitation will expire only on 31st of March 2022. Certainly, therefore, the Relaxation Act provisions will not be applicable. In any event, the time to issue notice may have been extended, but that would not amount to amending the provisions of 151. So, para 22 is very crucial here. Respondents have relied on taxation and other laws, TOLA 2020, inter alia, and the provisions of section 151 and 151.2, which were originally expiring on 31/3/21, which stand extended to 31st of March 2021. According to the income tax officer, the statutory approval for issuance of notice under 148 of the Act for the assessment year for 15-16 may be given by the ranger as per the provisions. Here, what the income tax officer has tried to do is here in this case, Voltas, the notice under 148 was issued on 31/3/21. And the approval was sought for under 151 by the additional Commissioner of Income Tax. Here it's a case where the scrutiny assessment under 143 was completed, wherein as per the law as on that date, 151 mandates that the principal commissioner should accord satisfaction. Department tried to contend that department tried to take shelter on TOLA, saying that 31st of March 2021 it expires, but coming to the TOLA notification, it extends my time limit to 31st of March 2021. That is not the case here. Here the 4-year period extends even prior to that. So therefore, the Bombay High Court says no, this is not the right way to do here. Since the TOLA does not only say restrains you, the 6-year limitation, the period of 4 years cannot be taken into consideration. You say 4 years is the only limitation, but the old Act says 4 years or 6 years. The 6 years period for 2015-16 ends on 31/3/22, and you still have time to issue notice till 31/3/22, and therefore you cannot take cognizance or shelter under TOLA. That is what the Bombay High Court has clarified. Now, the most important thing that I would like to address is the various decisions of the Supreme Court, various writ petitions filed before the Supreme Court has been quashed, and two notable decisions of the Gujarat High Court and the Allahabad High Court plays a vital role here. The case of Kinara Industries and Rajiv Bansal. So these two are the very recent judgments pronounced by the Gujarat High Court and Allahabad High Court. Rajiv Bansal is pronounced by the Allahabad High Court. Now, yes, Rajiv Bansal is by the Allahabad High Court, wherein the assessment years, the notices issued were for the assessment years 13-14 to 17-18. And the court did not quash the notices here. Surprisingly, the court held that the department cannot take shelter under TOLA 2020, and you cannot count this to be extending the time limit for you to issue notices. But while taking note of all these facts, the court only directed the assessing officer to deal with the notices in accordance with law. While doing so, the arguments of the petitioner councils and the respondent income tax standing councils were recorded. It's a case where the first time the theory of time travel propounded by the CBDT, it is not propounded by the Supreme Court decision or TOLA, it is only propounded by the CBDT. So here CBDT tries to say that the theory of time limit works. And surprisingly, the new theory of propounded by CBDT is like something very fascinating. Say, for example, how does this theory of time travel according to the department works? If we take this example for assessment year 14-15, the original time under 140, so let's say the original time limit expires on 31/3/21. And here, subsequent to Supreme Court decision Ashish Agarwal, all the notices that were issued under 148 were deemed to be construed as 148A-B notices, as show cause notices. And therefore, they'll have to provide information. You will have to follow the procedure under 148 capital A. So this notice initially issued on 31/3/21 has gone through a process after the Supreme Court's decision in Ashish Agarwal. And at one point, the 148 AD along with 148 is issued, say for example, on 15/8/2022. Now the CBDT department says this 15/8/22 should not be the date of 148 notice. It relates back to 31/3/22, saying that that is the original date of notice and not the extended date. Here there is a conflict between the dates. Here there are two notices under 148 being issued. One is the initial notice under 148 under the Unamended Act on 31/3/21 for assessment year 14/15. After the various course of proceedings in 148 capital A, there is one more notice issued under 148 along with 148 AD order 15/8/2022. Now the question is, what should be considered as the date of notice issued under 148? Whether is it relates to 31/3/2021 or is it 15/8/2022? This has been answered and elaborately discussed in Kinara Industries. You can see the screen that I've shared now. The time travel theory propounded by the CBDT has been very well examined by the Kinara Industries at para 26.1 and 26. If I can read this, it will clarify the position. In the CBDT circular, traveled back theory is applied. The due date for completion of reassessment proceedings would be 31/3/23. Here, with respect to Kinara Industries, the subject notices under 148 is issued for the assessment years 2013-14 and 14/15 alone. However, in all cases for the assessment years 13/14 and 14/15, where original notices issued between 14/21 and 36/21, and fresh notices under 148 are issued in post Ashish Agarwal's judgment, the due date for completing the reassessment would be 31/3/24. Here it's interesting that the department has taken a different stand, has argued in a different way. The department itself has accepted that the due date for passing of the reassessment order is 12 months from the end of the financial year 2022-23. That is, the fresh notice under 148 dated 15/8/22 is 31/3/24, which is in contradiction of the board circular proposing the travel back theory and the actual application of amended law. Now, the theory of time travel in the notification is not tenable. The notices originally issued under 148 would be converted into notice and show cause notices under 148 AB, and thereafter, while issuing the fresh notice under 148 read with 148 AD, the act would relate back to the date of original notice under 148A. This is the theory propounded by CBDT. The new law would apply retrospectively to the notices from such original date. The amendment is not retrospective, and therefore the time travel would not be permissible. So here, in this case, the Kinara Industries, the High Court has very well clarified the position that time travel theory and extension of time limit is not propounded by CBDT, and assuming so it is propounded by CBDT, it emanates from an erroneous interpretation of the Supreme Court judgment in Ashish Agarwal. The earlier edition, which I tried to attempted to dwell in, was Rajiv Bansal, wherein the aspect of time travel theory has been discussed in a particular way. This Rajiv Bansal was taken on further appeal by the department, by an SLP very recently, and the Supreme Court has admitted the SLP and posted the case for hearing on 10th of July 2022. Now, this being the position, what would be the impact of these judgments and these overrulings as such? Because the Kinara Industries, on the other hand, both Rajiv Bansal and Kinara Industries, they totally dwell into the aspects of time travel theory, wherein the Supreme Court now has stayed the operation of Rajiv Bansal, saying that 2013-14 and 14-15 has to be stayed completely, the proceedings. Now, assuming for a moment, if Kinara Industries goes up before the Supreme Court, the department may not survive, because Kinara Industries is where the Gujarat High Court deals elaborately in aspect of freezing of time limit. Apart from the time travel theory, the department also recognizes and attempts to create a concept called the freezing of time limit. So it is again pertinent to go back to the TOLA 2020, wherein the department, the freezing of time limit has been established by the department. They've got caught here. This has been rightly captured by the Gujarat High Court in Kinara Industries. I have highlighted the portion. Provided also that where the specified act is the Income Tax Act and the compliance relates to furnishing of return under 139 thereof for the assessment year commencing on clause B, the 1st of April 2020, the provisions of this subsection shall have effect as if for the figures, letters, and words 31st day of March 2020, the figures, letters, and words 30th day of November 2020 had been substituted. It is clarified. There is no doubt. Coming down for a minute, the proviso to subsection 3 provided also that the extension of the date as referred to in clause B of subclause 1 of third proviso shall not apply to explanation 1 to 234 capital A of the Income Tax Act in cases where the amount of tax on total income as reduced by the amount as specified in clauses so and so exceeds 1 lakh rupees. So here at one point the department tries to say that the concept of freezing of time limit applies only with respect to notices issued under 148, whereas on the other hand they will levy interest under 234A starting from 139(1) provision. So this has been captured by the Gujarat High Court at para 36. You can see the screen sharing. I'll just read that. The concept of freezing of time limit or permitting the revenue to travel back in time, the TOLA Act does not endorse the said concept, nor is it available with the case of Union of India versus Ashish Agarwal. The first proviso of TOLA Act provides that the extension of date as referred to in subclause B of clause 1 of third proviso shall not apply to explanation 1 to 234 capital A of the Act in cases where the amount of tax of total income has been reduced. The very fact that the revenue has charged interest for belated discharge of financial burden would go to prove that the time had not frozen. The department's argument all these days were that the time limit freezes and it stands excluded. It is not so. According to the TOLA Act, it is very clear that time limit does not freeze as a whole. It cannot be said that time limit freezes only with respect to 148 and time limit starts sticking with respect to collection of interest on 234 capital A. This cannot be the intention of any act. So therefore, when the Rajiv Bansal decision has been stayed by the Supreme Court, we were all afraid that about the fate of the decision. Considering this aspect, if 234A concept freezing of time limit is captured well, and if that is being projected in a right way, I think we still have a chance to quash all the notices under issued under notices under 148 for assessment years 13-14 and 14-15. But otherwise, for the assessment years, remaining assessment years, the defenses under 149(1) with respect to the monetary limit of 50 lakhs and more than 50 lakhs shall be applicable. So to conclude, I'd only say that the CBDT has only tried to, or rather attempted to, thrust their own interpretation by giving a device which is not the intention of the Supreme Court, nor the TOLA Act, nor the Finance Act. TOLA cannot override, all these arguments were already placed before the Supreme Court. TOLA cannot override the Finance Act. The explanations, though struck down by the Delhi High Court in touchstone holdings, it only curtails the function of 149. And moreover, while rendering the touchstone, there are two more decisions that I'd like to point out that is not relevant actually here. But before the Supreme Court decision in Ashish Agarwal, there is this landmark decision of Manmohan Kohli by the Delhi High Court. And subsequent to the decision of the Supreme Court in Ashish Agarwal, there is one more landmark decision in touchstone holdings, wherein the only parallel line that could be drawn is that Supreme Court judgment has been misread. And moreover, in Manmohan Singh Kohli, paragraph 98 was alone considered, which cannot be the intention anywhere. The notifications and explanations, the explanations appended to the notifications were declared ultra vires, yes. But what Touchstones goes to say is that the notification extending the time limit for issuing notice time barring assessments until 30th June 2021 was not struck down by this court. That is not the intention of the legislature or the Manmohan Kohli or the decision of the Supreme Court in Ashish Agarwal. So therefore, all this emanates from the erroneous interpretation of the CBDT, giving a different color to the decision of the Supreme Court in Ashish Agarwal. If this is read in true spirit and a conjoint reading of TOLA 2020, read along with the decision of Supreme Court, wherein defenses were given to us under 149, and moreover, the Supreme Court never even whispered about what is original date and how the extended time limit will apply anywhere. So this theory propounded by CBDT is erroneous, as we all know, and that is before the High Court. And Touchstone Holdings, which where the instruction under 1 of 2020 was challenged, the virus of the instruction, that has been dismissed by the Touchstone by Delhi High Court. And SLP, I believe, is pending before the Supreme Court that needs to be followed with. So we hopefully believe that the Supreme Court, by going through this 234 capital A freezing of time limit and the conjoint reading of Ashish Agarwal's the true spirit, all the notices issued under section 148 under the Amendment Act for assessment years 13-14 and 14-15 are liable to be quashed, and it will be quashed. With this, I end my presentation, and I just pass on the mic to Mr. Anand.
Thank you, Dinesh. That was a wonderful presentation.
Thank you, Dinesh.
Sir, yes, sir.
There's first question from me, Sridhar. Yeah.
Yes, sir. Yes, sir.
Dinesh.
Yes, sir. Yes, sir. Am I audible, sir?
The first question is you referred to one dependency of SLP, and what is there any interim order passed by the Supreme Court?
No, sir. No interim order passed by the Supreme Court.
Okay.
As of now, there are two SLPs that I would like to bring to your notice, sir. One is against the Delhi High Court's decision in Salil Gupta. Salil Gupta is a case where the instruction under 1 of 2022 was challenged. That was dismissed. That was actually upheld by the Supreme Court. And the Rajiv Bansal is where the Supreme Court has stayed the orders of the Allahabad High Court. So I think against Touchstone Holdings, the SLP is still pending. I think it will soon come up for hearing, probably in the month of June or July.
What is the impact of that? The second decision which you referred, the Supreme Court stayed the operation of the judgment.
The Rajiv Bansal decision, sir?
Yeah, correct.
No, Rajiv Bansal basically deals with theory of time travel propounded by the CBDT. CBDT only says that, for example, I think I gave an example. There are two dates of 148 notices issued. Literally, there are two notices. One prior to Ashish Agarwal and one in compliance with Ashish Agarwal. So the CBDT is trying to draw a line that the notices issued subsequent to Ashish Agarwal, that is along with 148 capital AD, that cannot be the notices originally issued. This notice relates back to the original notice 31/3/21, and going by this theory, they will take shelter in the notification and that will stand extended till 36/21. So therefore, they can issue unamended notice under 148. So this has been quashed by this has been directed by the Allahabad High Court to consider as per in accordance with law. So This has been challenged by the department before the Supreme Court, and Supreme Court stayed the operation of this judgment. So as of now, the notices are stayed and there is no operation as such. So still there is a confusion as to what will apply and how it will apply, the theory of time travel, or whether at all the freezing of time limit will apply or not.
Thank you.
Moreover, yes, sir.
Any other question?
I think Ashish.
Yes, sir. Dinesh, I was just asking the question because the Supreme Court only replaces the 148 AB notice. So after the 148A process is when you issue the 148 notice under the new law. So therefore, as far as 13, 14, 14, 15 goes, there should not even be a question, right? Because we've crossed 31st March 21 by the time Supreme Court decision even came.
No. That is not the intention of the Supreme Court. See, the only dispute before the Supreme Court was there was no provision for us to issue notices under 1314 and 1415 subsequent to 14 on or after 1421 because the original time limit expired on the date. So the
Correct.
Supreme Court only said you treat all the notices as 148 AB show cause notices and proceed with the new law. By doing so, it also said that you have differences under 149(1). So here, two notices come into picture. They operate. Two notices cannot operate parallelly. Though by Supreme Court decision, one notice is put to silence, the department is now saying that the notices issued subsequent to Supreme Court decision will only have a stand if at all they want. The department literally wants the notices issued after 1420, after 148 AD to be construed as notices as the original notice. That is not the intention of the Supreme Court. Supreme Court only said you can proceed further. That's all. Supreme Court never whispered about the original date or the extended time limit. This is my understanding.
Correct. I think we are on the same page. So accordingly, for 1314 and 1415, our stand should be that the notices issued after following the 148 AD process should be bad in law, right? Because they will be beyond 6 years.
Yes, it will be beyond 6 years. And moreover, the notices, the instruction, if you see, only for the first time you can see the instruction comes out with a theory called time travel to the original date. Nowhere the Supreme Court decision or TOLA, they talk about the time limit. And moreover, TOLA section 3 only talks about any time limit. It doesn't say whether it's extended time limit or original time limit. It is only original time limit. It is only extended time limit. So therefore, even going by the department's own TOLA, notices issued after 148 AD along with 148 AD should be the notice under 148. It cannot relate back to the prior notice.
Correct. I agree. Thanks, Dinesh.
Yeah, thank you.
Any other question? Thank you, Dinesh.
Thank you.
Shall we move to the next speaker, sir?
Yeah.
1 minute. 1 minute. For April and May, we will be in Zoom. And from
June onwards,
we will try to fix the meetings physically. And I need more participation, more active participation from the lawyers side and the CS side. So that is very crucial because according to me, tax litigation, the combination of lawyer and CA it's a deadly combination. So that has to be encouraged. And I need more participation in the coming months. Anand, you can take over.
Yeah, that was quite adversarial, sir. Dinesh, that was quite adversarial speaking on the topic. Now I think it's time we go to a less adversarial topic.
I think Dinesh, Anand, Dinesh should be given another day for other Supreme Court judgments to be analyzed.
Yeah. So now we'll go to a conflict management where it is less adversarial. Over to you, Ashok. Ashok is taking the topic on online dispute resolution in alternate dispute resolution. This is a non-tax topic. Ashok, over to you.
Yes, good evening, friends. At the outset, I would like to fondly remember with gratitude and respect my senior Sri V. Ramachandran and Sri K.J. Chandran, who had inducted me into RBA. Many thanks are also due to Mr. T.N. Sitaraman sir, who has been very affectionate and guiding me through this. It has always been a pleasure addressing before the seniors and friends in RBA. Probably I am the only speaker who is a member of an RBA and has spoken more number of meetings on non-tax issues rather than tax issues. I thank this opportunity to the committee, president, vice president, treasurer, and the secretary. If question is asked as to what is ruling the world now, the straitjacket reply would be technology. If not for this technology, today there seem to be no field which can exist. Right from collecting donations to performing brain surgery, the use of technology has enhanced its operations. Our courts too had started using technology. Though initially our computers were used as a glorified typewriters, luckily the same is not the present condition. Thanks to the tech-savvy judges and their efforts, most of the technological advancements are seen in the administrative side of the justice rendering system, just like how an appointment is registered in an hospital. On the procedure of justice rendering system, there has been some encouraging development, especially after the COVID-19 situation, when we really started to understand the physical presence is not required for arguing a case. Today, we even found that our president was addressing from his car. So the physical presence is absolutely not necessary for any forum, and only the forum by way of video conferencing would resolve the issues. So such has been the effect of COVID-19 that we started developing new arena of addressing the courts. We realized that prior to COVID-19 that we would have a chance of addressing courts over a video call. Today, that has become possible. Even the slightest rise of COVID, we have now seen the electronic media coming in, and the medium is being effectively put to use. As the Supreme Court Chief Justice has said, these electronic medium is not just to be used as COVID relief, but also it has to be put into effective use. In my opinion, tech can be used at its best in ADR rather than in adversarial system. In adversarial system, there are many limitations, whereas in ADR, these adversarial aspects have been relinquished, and today we can enforce tech in ADR methods. One such tech-based resolution forum is ODR. ODR would expand to online dispute resolution. It has been defined as a mechanism of resolving disputes through the use of electronic communication and other information and communication technology. The potential of ODR was realized by the UNCITRAL in the year 2016 itself. And it had submitted a technical notes on the ODR. It is also expected that the e-commerce would increase to 8,148 billion by the year 2026. Currently, it is wagering around 6,310 billion. Out of the 7.8 billion population worldwide, 6,841 million people are subscribed to smartphones, and internet access is available for almost 5.03 billion people. This would only explain the magnitude under which the tech is growing and how the World Wide Web is being put to use. Having said that, now ODR is being explored in various forums. The growth of ODR has been going on meets and bounds. Recently, I had come across various types of ODR being put to use in various forums. Q&A sessions are also being conducted by using ODR methodology. Counseling support, grievance, mediation, assistance for case management in ADR, practice ADR. We are today going to see how ODR can be applied in arbitration. In my personal opinion, I feel ODR is quite apt for arbitration mechanism. We all know that arbitration is the mechanism by which a civil dispute can be resolved and a finality can be arrived at which can be executed. Before going more into the ODR and in arbitration, I have been asked to give a brief introduction about arbitration. Now, then, the question would be, what is arbitration? We all know that in the contemporary method of resolving civil dispute, we all go to court, civil court. The process of going to civil court is quite cumbersome. You need to have the expertise of an advocate to help you out in various formalities that has to be complied with. It is highly procedural and the economics does not meet the ends. And more than economics, the time is a big constraint. What would be a system if I say that all these difficulties of a civil court is removed and you have a system whereby you can have your dispute resolved in no time, at a lesser cost, and in more effective manner? This is available in arbitration. Arbitration is a forum by which the parties decide how they want their dispute to be resolved and the manner in which it has to be resolved, who has to resolve it, and how they are to execute it, where they have to arbitrate. Everything is decided by the parties. Such circumstances, the entire control of their litigation is with the parties themselves. So the parties can actually decide on the number of arbitrators that are required to resolve their dispute, what should be their qualification. If it is a tax-based dispute between two companies, then they can, who has to pay and who has to suffer and what are the equations, everything. Then they can appoint even a tax lawyer to have their arbitrator. Or even a chartered accountant can sit on an arbitration between a partnership dispute where accounts alone is the prime concern. Appointment procedure, how an appointment has to be made, can be decided by the arbitrators, by the parties. The place and seat of arbitration, namely the jurisdiction, also can be decided by the parties. They can take a conducive jurisdiction and have their arbitration jurisdiction in that place. Venue can be fixed by the arbitrators. Language in which they want to resolve can be fixed. And this, what can be fixed, goes on and on according to their will and pleasure. Now we are going to see how the arbitration procedure can be put to use in an ODR system. That is where the present topic is going to be. Here, I would like to share screen. Is my screen visible now?
No, Ashok.
Okay, one second. Anand, I will switch over to my other laptop. I don't know why this iPad I'm not able to screen share. Just a moment. Sorry, friends, for the inconvenience. I think now my screen is visible. So ODR is a concept. Now, is arbitration conducive for ODR? Is the question that first raises. Now, in our
Excuse me, sir.
yes,
Your this file is not yet visible.
my screen is not visible.
Yeah. The contents, the names of files are there, the list of files, but the contents are
Not
not.
started, sir. Is not it started?
No. I think 1 second. I'll again share it once more. Now, sir.
Yeah, now it's fine. Yeah, thank you so much.
Fine. Thank you. So while we want to incorporate ODR in arbitration, we need to first find out whether it is conducive. What are the requirements of ODR and the hiccups that ODR would face in arbitration? If I consider that, then the major aspect that I find is with respect to the communication of the dispute or the notice to the parties. Because in ODR, the concept is going to be only documentation, and there is not going to be any other aspects. And the communication aspect, how do we communicate? Now, Arbitration Act under Section 3 provides for the communication of notices. It allows that the parties can agree the mode by which the communication can be held. Therefore, the parties can agree that their communication shall be in the form of email or voice message or SMS, short message services. So once this has been agreed upon between the parties, then the communication hurdle is crossed. Next comes the hearing and the procedure. Does the Arbitration and Conciliation Act provide for the structure as in ODR, where there may not be a personal hearing or a physical hearing? For that, we go to Section 29B of the Arbitration and Conciliation Act, which provides for fast-track arbitration, wherein the parties are to abide by the fast-track arbitration. They have to decide on the said aspect. Arbitrator to decide only on the pleadings and documents. In such cases, he may not have the physical hearing or oral hearing at all. So if the parties agree that they want a fast-track arbitration and they do not want a lengthy oral hearing, they can always go in for their document only arbitration. There is no mandatory requirement which would say that there should be an oral hearing. The parties' agreement will prevail, and the concept of ODR can be decided even within a period of 6 months. Now, with this as the background, we in Cinica, we wanted to bring in technology and wrap it with the effect of justice rendering system. We wanted to produce a system wherein the end-to-end is with the use of WWW, that's World Wide Web technology. We have thus created a platform called www.cnica-odr.com. In this platform, if you can, I'll be showing you shortly. What we have enabled is the documents and pleadings are all to be uploaded on digital manner, and the communication shall be only in digital form. We have brought in two different systems. One is automated and the other is manual. This way, we have complied with the provisions of the Act and see to that every process is also legally possible, and it also can makes it convenient for the parties. For this purpose, we have our CNICA ODR rules 2023. This rule provides the various aspects by which the arbitration can be done on ODR platform. Therefore, the parties to the dispute can just say all disputes between them can be resolved by arbitration through ODR, CNICA ODR platform. Once they say this and incorporate it in their agreement, the rest flows. All the conditions and the rules will apply, and the parties will have the benefit of redressing their disputes through ODR platform. We have incorporated the concept of 29B as I stated earlier, and we have mandated that email and mobile number are required, without which this process cannot be done. The documents are to be uploaded only in the form of JPEG or JPG or PDF. Of course, we are also providing a form, a ready-made form available, wherein the parties who are not well aware of the technical aspects of law can also type in their grievance and upload it. Full opportunity to file pleadings and documents are provided, meaning we have got these. We start with a claim statement, followed by statement of defense, then followed by a rejoinder, then again followed by a sur-rejoinder, so that the parties are not deprived of making their plea at any point of time. Again, we also have the concept of filing written arguments, wherein the parties can make their submissions even at the conclusion. The other aspects of these rules are the confidential mode of appointment of an arbitrator. We have created a panel of arbitrators. The arbitrator for each case will be picked from the list of arbitrators empaneled by the system itself. In other words, the system on random basis would pick the arbitrator and appoint the arbitrator. This way, the confidentiality in appointing the arbitrator is maintained. As soon as an arbitrator is appointed, he has to file his impartiality and independence declaration, which is as required under Section 12 of the Arbitration Conciliation Act. We have also provided a provision in case the parties seek for an in-person hearing or a digital platform hearing, they have to make a representation to the registrar of the ODR, who will have, in consultation with the arbitrator, decide on the methodology of having the hearing. We also aid the settlement process and provide an option for the parties to make application, interim application. There are provisions provided where the parties can suggest their methodology of settlement or file a memo with respect to the settlement that they have arrived, and the arbitrator, on going through that, can pass an award based on the memo of settlement filed by both the parties. Now, I had stated there are two modules which are available in Cinica ODR's platform. Now, these two models happen to be on automated platform and manual. The reason for it is more important before going into the what is meant by automated and what is meant by manual. Now, automated would govern all the references which come through the Cinica ODR rules in total, where there is a Cinica clause, ODR clause incorporated in the agreement between the parties. However, in cases where the parties have agreed that they will have a document only arbitration and their mode of communication will be that of email, and they have given their mobile number, then in that case, they can opt for the manual operation. So what happens in an automated process is the presence of ODR clause becomes mandatory. Without the ODR clause, Cinica ODR clause, the automated process cannot be availed. Once there is an automated clause is process is entered into, the entire process of time for each and every act is designed by the system itself. For instance, on a claim being registered, the arbitrator will be appointed within 48 hours. And the appointed arbitrator within two days or 48 hours has to provide his or her consent, or in case of a rejection, I am an interested party, the impartiality would be affected, then that should be notified. On notification, the automated process would again go to the round robin basis and appoint another arbitrator who will have to give his declaration within 2 days. On providing the declaration, the next stage of filing the claim statement will automatically be sent, wherein the parties will receive the notice of hearing, voicemail, and text message stating that the arbitrator has given his consent and that the claimant has to file the restatement of a claim within a period of 10 days. There may be a requirement for extension. In such cases, the party seeking for an extension will have to seek for an extension, and that extension is considered for a maximum of 7 days. Such is the automated process where every other stage is taken through by the system itself in an automated process. However, in a manual process, the Cinica ODR clause is not required. However, what is required, as I stated earlier, is the email ID and the mobile number. These are mandatory and that has to be provided. Next is the entire process of arbitration is governed by the arbitrator. The arbitrator takes control of it and he awards the time for each and every stage, like the time for filing the claim statement, time for extension of filing claim statement or statement of defense or rejoinder or sur-rejoinder, or even the written arguments. Only with the intervention of the arbitrator, the next stage will process. Supposing the arbitrator is not available for about 2 or 3 days to log in and give the next date, the system will be holding it for the arbitrator to come and give the date. So the entire governance of the process would be done by the arbitrator himself. Now, I said the arbitration in ODR commences in our portal in this manner. At the outset, the claimant or either of the party who wants to get into arbitration through ODR method, they have to sign up and we need to have their credential. For signing up, as I said, we need our email. Next, we need the mobile number. The rest of it is on academic basis. We do collect the address, physical address also, as it has to be mentioned in the award. Now, once a registration has been made, the case management page would look similar to this, wherein the same person can raise new claims and then he has to click on new claims. The existing claim which has already been registered will appear here, and the portal has to decide whether this is a automated process or a manual process, and the claim has to be assigned according to that aspect. Now, this is the screen in which the portal, namely the registrar, will have to decide whether it is a manual process or the automated Seneca process. For this, the registrar would view the document, namely the agreement by which the dispute is referred to ODR, and the reference letter, which are mandatory for the parties to upload at the time of registration. Now, on going through the agreement, it would be clear whether the parties have agreed on a Seneca clause or they have agreed to arbitrate using the module of sending communication by email and WhatsApp, or mobile. In such cases, we clear the manual operation is made. Otherwise, if it is a Seneca clause, then we have the automated process. Now, once this is done, the registration, in fact, this I should have gone upfront. This is how the, sorry about it. This, the claim is fixed. The address of the claimant is fixed, and the number of additional claimants, if any, they have also mentioned. Again, here, the name and address of the email and the email address and the mobile number of the respondents are also made. This is the place wherein the agreement date is given, and the what nature of claim is mentioned, the amount claimed is mentioned, and the claimed agreement is uploaded here, and whether it is a sole arbitrator. I have to state here, it can be only a sole arbitrator. Under 29B, only disputes relating to sole arbitrator can be brought in, so it has to be only a sole arbitrator. And then the reference letter is mentioned here. Now, once all these things are filled up and uploaded, we get the next screen. The moment the registration is completed, an email is sent in the following content, and a voice message and a text message. All the three are sent to the parties and to the arbitrator also, asking him to reply to his appointment. This is the text message that they would be receiving. Now, this is the screen in which the arbitrator has to upload his consents and disclosure of his impartiality. This can be done in two forms. One is he will fill up this details in this form as to his prior experience, number of ongoing arbitration, his present and past relationship with the parties, his circumstances, if any. On the contrary, he can also upload it in a physical form after filling it up separately, and then it can be uploaded. After uploading, he has to give a disclosure that he is giving a consent to be an arbitrator and he is eligible to be an arbitrator. And by clicking the submission button, whoever does it, it is understood that the person has submitted his document, and it is equivalent to a document submitted after signing. These aspects are provided in the rules itself. Now, the claim statement, again, it can be uploaded in the provision given here, or the claim statement can be filled up where the parties can type out what is their facts, what is the nature of dispute, grounds, jurisdiction, limitation, and the relief that they are seeking for. With this also, the system will convert it into a claim statement and have it there. So people who do not know the methodology of drafting a plaint or drafting a claim need not worry. They can always follow this system, and they can upload their claim statement. Now, once a claim statement is filed, then the administrative fee and the arbitrator's fee is collected. That is 50% of it is collected, and the parties are required to make that payment. The moment the claim is filed or registered, the respondent also gets a email asking him to register itself. This will be appearing for the respondent, where the respondent will have to register the claim and proceed further to view his case management page. Now, every case will have a docket sheet. This docket sheet will provide the documents that are filed by the arbitrator, documents and information given by the claimant, documents and pleadings filed by the respondent. Here also, the register, whatever in the register box, whatever has occurred in the different stages of the arbitration, online arbitration, will be mentioned here. The details of the case number, the amount claimed, and the details of the claimant and respondent and the payments made by them will also be exhibited in this case docket. Now, the features available in our ODR are that interim application under section 17 can be filed. The person who wants to, the respondent or the claimant who wants to challenge the arbitrator under section 12 or 16 can do so. Counterclaims can be filed by the respondent. Pleadings, claim statement, statement of defense, rejoinder, reply to rejoinder, that is SR rejoinder, everything is feasible. Written arguments, and after the award, if there is any clerical mistake, that an application for rectification can also be filed. So the time, roughly it takes around about at the most 60 days to complete the entire process in this ODR method. Interestingly, the parties need not be in the same city. They need not visit any place. They can sit in their own places on any day at any time, and they can proceed with the arbitration. With this, I conclude the presentation on ODR, and if anyone has got any queries, I'll be glad to answer.
The floor is open for questions.
Maybe we are going to miss Devanathan sir here.
No, you are not on the adversarial topic, Ashok, so you will not face any questions.
Yes, I understand. And this being a topic, so far it has not come out to light, and this concept of ODR is not taken off in this part of the world, and that is another aspect. Another aspect is, I need to say that ODR today, which is prevalent, is in the form of a minor dispute resolution within the system itself. Like, say, for instance, Amazon has got its own ODR system mechanism. Similarly, PayPal has got its own. So what they do is a grievance cell is created. That grievance cell is what they arise out at as a ODR system. There they answer that grievance. That is made as an ODR platform. Now we are going one step ahead, and we are saying that we will have the entire arbitration itself here, and that's how we are focusing to have all these disputes also addressed through an online platform.
In fact, even in taxation system, with dispute resolution, with dispute resolution is form of arbitration. Actually, the only thing where we are missing here is we do not have a person other than the person from the department. If we have a person with a judicial background, if the department is balanced with another person who is independent of the department, is neutral to the department, then it will the ADR will work out even with the dispute resolution forms.
True.
Vasu?
Okay.
Vasu, will you go ahead with the vote of thanks?
Yes, sir.
Before that, I would like to thank
giving me this Vice President Anand and Secretary Mr. Vasu and Sendil, the Treasurer, and the core committee for giving me this opportunity.
Thank you. Yeah, I'm here for a vote of thanks. Firstly, this is the first study circle meeting for this period. It has went on very well. It was a very absorbing session of more than 1.5 hours. Our Dinesh Inbadu has taken us through the controversy revolving the 148A, Ashish Agarwal and the CBDT circulars. And the controversy still goes on. We don't know when it's only litigation is only multiplying on this aspect. We all should be happy on the continuing litigation, I think. But we also need to see the end to it very soon. Because the Assis cannot be put in the boil for very long. Number one. And number two, I think there are quite a few other decisions that have come through after this, apart from the 148A, 153C controversy, 215, 1023C, all these Supreme Court judgments have also have an impact in the pending court proceedings and assessments and all. So we need to also discuss on all these issues. We'll have it in probably the next or after this sessions. Thank you, Dinesh. It was a very interesting, absorbing session by you. And next, Ashok was an absolutely new topic for all of us, ODR, and you have taken us through the procedure that is involved in ODR resolution. I think, is it ChatGPT and AI, is it going to impact ODR?
It will complement ODR's growth.
Oh, very good. You're not going to have any adverse impact on this ODRs.
No, because we are part of that.
Oh,
Yeah.
fine.
Because when we say that the entire process is automated and it goes from one leg to another, it is almost an AI which is implemented.
Oh, good. Right. Excellent. Thank Ashok for a fine display of the ODR rules and procedures to make anybody who attended the session to approach it with ease. Thank you to both the speakers. We will in May month we have the third week of May we will have another second study circle. It's most likely one of the topics will be on GST. Other topic we will work it out and inform at the earliest. Thanks to all the attendees. It was a good session, and we hope to get more chartered accountants into the fray, and it's going to be it's a cooperation between the advocates and chartered accountants going to help us a lot in resolving all the disputes. Thanks to all.
Thank you, sir. Thank you, sir.
Yeah.
Thanks everybody. We'll end the meeting now.
Thank you.
Thank you.